this video, we will begin our discussion on the numerous courts of the common law. In essence, the United Kingdom has what could be considered as one of the most rich and diverse court structure in the world, something that many other countries have also learned from and implemented on their own. But our discussion will stem from what it used to be all the way to salient aspects of how it developed and evolved today. So to begin with, we must consider what is known as the King's Council. Now, the King's Council could be considered in terms of a hierarchy as being the overarching leader or the apex body in relation to the court structure of the United Kingdom of England. Later, this was subdivided into what we now know as Parliament and what was then the Privy Council. By and large, the King's Council was made up of the Court of Chancery, the Court of Exchequer, Court of Common Pleas, and the King's Bench. Now, when it comes to each of these courts, something that we will look at individually, considering the fact that each individual court represented a different branch in terms of governance and justice and dealt with predominantly a very specified set of actions or functions and tried not to encroach on each other. So we'll start off our discussion to begin with from the Court of Exchequer, but before we proceed, one major thing that must be seen or must be considered, something that we need to identify as being somewhat different from our initial discussion in our previous lesson on the Anglo-Saxon legal system, is the fact that we are now slowly beginning to see the fact that local courts such as the shires as well as the hundreds have somewhat diminished when we start discussing about these courts of the common law. This is, by its very definition, the inception of the common law. And we see that law has now become somewhat centralized within the Westminster Parliament or the Westminster infrastructure. Each of these bodies, as I mentioned, controlled itself, tried not to encroach on each other, and pretty much went about their business based on the specified set of tasks and functions which were allocated to them. So the very first type of court that we will be considering is that of the Court of Exchequer. This particular court can be equated to what we now know as the Treasury. Basically, it's the court that dealt with the king's money or any particular crime or offense related thereof. Now, on the one hand, the litigation of this was handled by the Crown, and it was headed by the king's treasurers. On the one hand, it was basically tasked with just crown business altogether, anything with the king, and if at all, below that hierarchy, any action which was brought about by those privileged. Now, what we must understand here is that by and large, at this point of time in history, there was a clear demarcation between those of wealth and privilege and those who are just commoners. Today, while we consider democratic notion in terms of many societies, these lines are somewhat blurred. But back in the day, you could see that, and it was bureaucratic and it was instilled, it was interwoven into the system or the administration itself. Now, the Exchequer of Receipts, something that I've mentioned here as well, dealt with fixed revenue, pretty much collecting of debt such as taxes and so on. But the actual task of going about and doing the day-to-day business was solely handled by what is known as the lower exchequer. They're the ones that handle the collection part of it. So the Court of Exchequer is its connected body that dealt with any disputes that would arise from it. For example, whether someone has paid or not, as well as whether there's a dispute in relation to the amount to be paid, and so on and so forth. Now, around 1290, this is something that became very popular because, as I noted, the Court of Exchequer dealt with the king's money, with pretty much state business, as well as in some instances one step below in relation to those of privilege, as I noted. But many private litigants tried to come in through that particular route, primarily because Exchequer was meant to deal with money owed to the king or debts owed to the king. Therefore, the methods used by the Exchequer to collect such money must be the best. The king will only sanction those things which are the utmost in terms of what's available at the time. So the private litigants themselves wanted that. Think of this in a modern context, such as a very expensive luxury car, which will introduce the newest technologies, but then later on, several years or even a decade later, those features will trickle down to much cheaper models. Same thing applied here. When the court system and the justice at large opened this facility up to others, private litigants actually preferred it. Now, one of the major premises, or rather the functions that the Exchequer was able to do, was that they were able to instill Exchequer writs, which were able to summon defendants from anywhere. That's quite the purpose of the writ instrument itself. Something that you would know if you watch some of my videos or the course on the English legal system. I'll link to it in the description below as well. And the card should appear on the screen for you to have a look at. Therefore, the claimants would claim that they could not pay the king his due because someone else was in default of them. In other words, when a dispute would arise in the Court of Exchequer, the excuse, or rather the defense that will be portrayed by a litigant, would be that I was not able to pay because I am owed money by such and such individual. Until he or she pays me, I am not able to pay the king. Therefore, this invokes a writ where the court is able to ask for, or summon rather, a defendant who is in default of this particular litigant in front of court. Now, we see Sir Matthew Hale quite eloquently note in A.G. and Pulteney that to make the king's prerogative a stale to satisfy another man's debt would be unreasonable. In other words, the Court of Exchequer and the justice system at large, the court structure, were now aware of this usurpation of the king's court system in order to proliferate, or rather in order to pursue personal ends. This can be seen later on when we do criminal law, for example, in relation to the history of English law as well as procedure, where in order for a litigant to bring a claim, the fastest route would be actually to defend yourself by implicating someone else for another crime. This was by and large completely haphazard. There were a lot of loopholes that were being exploited by people. This was just one of them. So that was a brief outline of the Court of Exchequer. This is our gateway into the courts of the common law. And as we move on, we will start looking at the different court systems, culminating in the Court of Chancery and the appeals process. Thanks a lot for watching this video. Make sure you check out some of my other courses available online and reach out for the tutoring masterclasses through the links below. Have fun, stay safe, and as always, obey the law.